My name is Caroline Browne, and I'm the Head of Regulation at the Human Tissue Authority with responsibility for our regulation of the post-mortem sector and related policy development. We're joined by about a dozen people from various parts of the country. Thank you all for joining us. You're very welcome. Before we get started, I'll run through some practical details. First of all, if you're having problems hearing me, let us know by typing into the chat field at the bottom of your screen. The webinar will comprise a PowerPoint presentation of around 40 minutes, after which we'll have a question and answer session. Please feel free to ask a question at any time by typing into that chat pane on your screen, and we'll make a note of these and come back to them at the end. As I said, if you have any technical difficulties, let us know. We're recording this webinar and it will be available on our website in the next week or two, but I think we're planning to email you a link to the web page when it's been posted online. Before I take you through Code B on post-mortem examination, I want to just remind you quickly of the status of the codes. So this slide has an extract from Part 2 of the Human Tissue Act, where the provisions in relation to the codes of practice are set out. So it says that we may, in carrying out our functions with respect to licenses, take into account any relevant observance of or failure to observe a code of practice when dealing with a matter dealt with in a code. So these are important resources for you to draw on, giving practical guidance and laying down the standards expected in relation to the conduct of licensed activities. They also form the basis of our superintendence of compliance with licensed activities, which, as you know, in relation to the post-mortem sector, are the making of a post-mortem examination, the removal from the body of a deceased person otherwise than in the course of a post-mortem examination of relevant material for use for scheduled purpose, and the storage of the body of a deceased person or relevant material for use for scheduled purpose. So this webinar marks the culmination of work that began in the autumn of 2014 to review and revise our codes and standards. In 2015, we carried out a public consultation, which elicited 79 responses altogether, most of which were positive. 10 came from licensed establishments, 31 from other organisations, and 38 from individuals. Of those, 16 were specifically in relation to the post-mortem code, and included submissions from the Royal College of Pathologists and the AAPT. We also held workshops in London, Leeds, Belfast and Cardiff, which were attended by around 200 people. In December, the codes and the standards received parliamentary approval, and from the 3rd of April, we will begin inspecting against them. Our new suite comprises 7 codes rather than 9, so we no longer have a separate code on disposal, nor one on import and export. Instead, we've included guidance on these topics in the individual codes where that's relevant, so that the advice is tailored more to the needs of each sector. Code A is the first of the suite of code, and it's our overarching code. So it sits alongside the others and includes information that anyone involved in licensed activity should read, regardless of their sector. The purpose of this webinar is to take you through the main changes to the post-mortem code and the standards, with particular emphasis on how these might impact on your day-to-day activities. Actually, our codes have been subject to review in the past, in 2009 and 2012, so we have been able to make some changes to keep them current. However, the standards haven't been changed since we began inspecting late in 2006, and we've taken this opportunity to undertake a wholesale review. But more about the standards a bit later. Let's begin with Code B on post-mortem examination. I'd first like to run through the key changes and to orientate you around the new code. In the introduction, we remind you of the underlying principles set out in Code A: consent, dignity, quality and openness and honesty. Although these principles have always been at the centre of our work, we've not stated them explicitly in our codes before. For the post-mortem sector, these principles mean that bodies of the deceased and tissue taken from the deceased should be treated with respect in an environment that is safe and secure, that the dignity of the deceased should be maintained at all times, that the needs of the bereaved should be met with care and sensitivity, and that their wishes should be fulfilled where possible. For the post-mortem sector, perhaps more than the others, there is a great emphasis on dignity and respect for the deceased, which is a thread that runs through the code as well as standards. So we've removed from the post-mortem code generic information on consent. That's all contained in Code A. This code has a new structure. After the introductory sessions comes the guidance relating to coroner's post-mortem examinations, as these make up the vast majority. Here you will also find guidance on disposal of tissue following the PM, criminal investigations and defence post-mortems. After that comes guidance specific to hospital consented post-mortems, with a focus on the information that should be provided to relatives of the deceased and what constitutes appropriate consent under the HTA Act. The later sections of the code cover a range of issues, such as training for staff, the removal of post-mortem tissue for scheduled purposes, the storage of tissue and bodies, and disposal. The new licensing standards are included in the code itself, making them more easily accessible to anyone who has an interest who is not directly involved in mortuary work, for example, coroners, their officers, police, bereavement services, and so on. And at the end of the code, there are several annexes, most of which contain information that spans the code. But I'd like to draw your attention to our new definitions of the terms must and should, which are contained in Annex A, which will make it easy for you to differentiate between what's a statutory or a regulatory requirement and what is good practice. We use the term must when we refer to a legal requirement derived from either primary or secondary legislation. And so there are some examples there. So, for example, the legal requirement to hold a license to store human tissue for use for scheduled purpose. We also use the term must when we're talking about your obligation to comply with our licensing standards, as they form the basis of our regulation, are the means through which we can supervise and assess compliance with legal and regulatory requirements. And the term should is used when we're providing advice on how to meet these requirements and giving examples of good practice. Very little has been removed from this code. Most of the changes are to provide further clarification of topics already included, to enhance the language, or to provide new guidance that wasn't there before. However, I've mentioned that we recognise there was some repetition between the consent code and the sector-specific codes, and we've therefore removed some of the generic information about consent. For example, the legal detail of who is able to give appropriate consent under the Human Tissue Act. Although it's important that you read Code A, everything you need to know about consent for post-mortem examination and the retention of tissue is contained in the post-mortem code. We've also removed the section on records management. There's a comprehensive guidance document from RCPath on the retention and storage of pathological records and specimens, as well as more general guidance on healthcare records management from the Department of Health. And of course, we have a licensing standards on records management. Quite a bit has been added, however, and I want to draw your attention to these sections in particular in the order in which they appear in the code. There's now a new section on offences under the Act, which appears in all the codes. The inclusion of this section means that you don't need to refer to the legislation itself to find out what is lawful and what is unlawful. I'm sure you'll be pleased to know that in relation to both consent and licensing, an offence is not committed if the person reasonably believes that they have the appropriate consent or that the activity they are carrying out is not subject to licensing. However, we strongly recommend that you refer to the code so that you do fully understand statutory requirements. There is new advice on the options provided to families by the coroner with regards to options for disposal of tissue samples, as set out in the coroner's regulations. This highlights in particular that there may be potential benefit to families of keeping samples, which it would be helpful to explain to them so that they can make a fully informed decision about whether or not to consent to the retention of samples. It also mentions that families' expectations should be managed when they consent for use of the samples for research, and that this is no guarantee that they will be used and they may be disposed of in any event. So where coroner's forms come back indicating that the family have consented or asked that the tissue be kept for research, we're proposing that they should know that that wouldn't necessarily guarantee that those samples would be used for research. In the section on coroner's postmortems, we've included a paragraph about scanning. This also emphasises the importance of managing families' expectations so that they're clear that this is the coroner's decision, and even if the coroner agrees to the use of scanning, a postmortem examination may still be required if the cause of death can't be determined. There's a new paragraph on samples taken for toxicological analysis, which clarifies when these are subject to licensing and consent. And the section on criminal investigations has been expanded to include information about the responsibility of the police with regard to tissue samples. And we had input from the Home Office into that section. This is followed by a short section on defence postmortems, which focus on the need to maintain written evidence of continuity in relation to the management of samples. We've included a new section in the code on removal of post-mortem tissue for use for scheduled purposes, which emphasises that removal must take place on licensed premises and includes the examples of A&E departments and operating theatres. In that same section, we provide advice on Sharp's injuries and the legal position with regards to testing to see if the deceased had an infectious disease. We know that mortuary staff are at risk of Sharp's injuries. There may be occasions when an injury occurs during a PM and there's the possibility that the person had an infectious disease, which needs to be established urgently. Because testing for infection is unlikely to be a factor in the cause of death, the coroner can't authorise the testing to take place. The legal requirements of the Act are that consent would need to be obtained from the appropriate person in the hierarchy of qualifying relationships for a sample to be tested to establish the presence of an infection disease so that post-exposure prophylaxis can be administered. When there's no immediate access to a family member, recent case law suggests that permission may be given by a judge, and that's all explained in the code. The section on storage has been expanded to include the storage of bodies as opposed to just tissue blocks and slides. So here we emphasise the importance of having storage facilities which protect the deceased and for which there are effective contingency arrangements and practices that preserve their dignity. It makes it clear that practices such as placing bodies unshrouded on trays, placing more than one body on a tray, or storing bodies in unrefrigerated storage aren't acceptable. It also contains guidance on the use of existing holdings for teaching, which we hope will help any NHS trust considering how to deal with legacy collections of specimens. Because there's no longer a code on disposal, the post-mortem code now contains much more information on disposal than it did previously, when it focused on the management of samples following a coroner's PM. The new code gives guidance on the various methods of disposal and includes reference to our 2015 guidance on the disposal of pregnancy remains. Finally, as I mentioned earlier, our licensing standards now form part of the code rather than being contained in a separate document. Review of our standards has provided the opportunity to reflect the changes that we've seen in the sector since we began inspecting. Overall, we found that many of the standards continue to be appropriate and fulfil their purpose to enable the HTA to make judgments about the suitability of licensed premises and the practices taking place there. However, we've raised the bar a little and moved away from the language of minimum standards, referring instead to licensing standards. I'm sure some of you will have looked at them on our website and you may have noticed that there are more of them. This is largely due to formatting. Till now, we've had a small number of individually numbered standards, each with examples of evidence of compliance. This has sometimes left establishments unclear about what precisely they have to do to demonstrate that the standard is met. It also introduces the risk of inconsistencies in our inspectors' decisions about compliance. Taking the individual standards and the examples of evidence together, the current standards amount to 73 requirements. The new set consists of 72 separate standards, so there's about the same number of requirements. A further benefit of this change of format is that we will more easily be able to undertake analysis of inspection findings and feed back to the sector about trends in compliance. I think it's also important to stress that we've ensured that these standards are in line with professional guidance from RCPAT on the coroner's autopsy and also with relevant HSE requirements where there are overlaps between our standards and theirs in relation to premises. So this is the approach we adopted to revising the standards. We decided very early on that we would maintain consistency across our sectors. So whichever licensed activity you're involved with, you will be required to meet standards on consent, governance and quality, traceability, and premises, facilities and equipment. This will be particularly useful for anyone who works across sectors or for DIs who are taking responsibility for an area outside the mortuary, for example, a research tissue bank. We looked back at our inspections data to assess the continued relevance of each standard and the patterns of compliance and to identify where there was scope to remove a standard strengthen a standard, or add a new one. We used what we've learned from HTA reportable incidents and the outcomes of root cause analyses to identify the activities that present the highest risk. This has been really important in ensuring that compliance with our standards will help minimise the risk of a serious incident occurring. We involved our regulation managers, whose knowledge individually and collectively about how establishments are meeting our standards has been important in informing where we should place more emphasis. We obtained early input from our sector experts, so members of our histopathology working group, to ensure that our assessments were correct. Our HWG includes members from RCPAC, AAPT, the Coroner Society of England and Wales, and the Forensic Science Regulation Unit of the Home Office, and it was important to us to obtain their advice and endorsement of our approach early on and throughout the period of drafting. We also set acceptance criteria for ourselves, which included checking to ensure that our standards meet the requirements of the regulator's code and that our approach was consistent with good regulation. Regulators must have regard to the code when developing policies and operational procedures that guide their activities and when setting standards or giving guidance. Amongst other things, we must carry out our activities in a way that supports those we regulate to comply, provide simple and straightforward ways to engage with those we regulate, and we must base our regulatory activities on risk, providing clear information, guidance and advice to help those we regulate meet their responsibilities to comply. We worked on the principle that each standard should be specific, measurable, achievable, realistic, and for the purposes of implementation, able to be achieved within a stated time frame. So I think we've met all these criteria. I hope as you begin working with them that you'll agree. But as I mentioned earlier, there's a new format with more individually numbered standards, which provides for greater clarity for you and your staff, for you and HTA staff, and will enable us to be more targeted in our assessment of risk. It also means that they're more easily mapped against other standards, such as those of RCPAC. In fact, we're in the process of updating our document, which shows the overlap between HTA standards and RCPAC guidance on the coroner's autopsy. A really important development is that where we've considered it to be helpful, we have included standard-specific guidance. Unlike the standards themselves, these items of guidance are not contained in the published codes and are available on the website in a separate document. This means that they can be changed more easily as we learn more about what is needed by the sector. The standards are still grouped onto 4 headings, but those grouped under the heading disposal have been brought into a new group under the heading traceability, which now has more prominence. So the 4 groups are consent, governance and quality, traceability, and premises, facilities and equipment. And of course, they reflect the 4 guiding principles set out in Code A. So by way of illustration, here is standard GQ2 in bold in its current format, followed by a number of examples of evidence of compliance. And here is new standard GQ2, also in bold, followed by individually numbered standards, each with guidance providing further information to help you comply or to improve your practice. I'm going to take you through each group of standards, highlighting the key changes that you need to be aware of. So in terms of consent, there's not been significant change to the consent standards, which still require you to have a documented policy and procedure on consent for post-mortem, training for staff who are involved in that activity, and information for those giving consent. The main change is that it's now a licensing standard that there is a ratified consent form to document the consent given. And of course, our model consent form is on our website for you to use if you need to. We also want to see that staff seeking consent for post-mortems have been assessed as competent to undertake this task, as obtaining valid consent for post-mortem and the storage of use of samples is so important. Assessment of their competency in this area can take several forms. For example, observation, procedural audits, audits of consent records to check for accuracy, legibility and completeness, and the maintenance of training records to demonstrate that staff have attended the necessary training. The governance and quality system standards have the most new requirements, and analysis of HTA reportable incidents has provided a rich source of information which has informed many of the changes. Firstly, in relation to standard operating procedures, There are some new ones included in the list in GQ1A. I've shown these on the slide for you, and you'll see that they take in a range of issues, including routine and contingency storage, movement of bodies, and access to the mortuary. Some of you may already have documented SOPs that govern these activities. If you do, we hope you'll look at them again to make sure that they are thorough, reflect practice, and mitigate any risks to bodies in your care. If you don't, you'll need to work on those in the months ahead. In relation to staff training, we want to see that staff are assessed as competent to perform their duties and that any visiting or outside staff receive a thorough induction into mortuary procedures. This is particularly important when staffing shortages mean that you may have to obtain the services of locum staff. Standard GQ1 sets out the requirements relating to particular mortuary activities, and I want to draw your attention to the first of these in particular. So from the 3rd of April, it will no longer be acceptable for APTs to eviscerate a body in preparation for a post-mortem examination without the pathologist having first carried out an external examination. To do so is contrary to RCPATH guidance and widely considered to be poor practice. We've also included standards on practices relating to body storage under governance and quality. We want to ensure that body storage practices don't in any way compromise the dignity of the deceased, even in very busy times when the mortuary is at or nearing full capacity. For example, practices such as placing more than one body on a tray, or placing bodies unshrouded on trays, or in unrefrigerated storage should not take place. The governance and quality standards include standards on incident reporting and risk management. New requirements are that there is a policy of candour when dealing with serious incidents, reflecting the underlying principles of openness and honesty, but of course giving due consideration to the circumstances of each case. We've also included the requirement for significant risks relating to the mortuary to be included in the organisation's corporate risk register. We have too often seen designated individuals and mortuary managers unable to effect the changes they need because their concerns are not heeded by the senior team. Ensuring that the mortuary has what it needs to provide a quality service is an organisational responsibility that needs to be reflected in how risk is managed. Moving on to the next group of standards on traceability. Good systems of traceability are key, as you know, to ensuring that bodies and tissue can always be accounted for and the risk of error is mitigated. And we know from incidents reported to us that where these systems are not robust or not observed by staff, the consequences can be very serious. Our new standards on traceability include a number of additional requirements which are set out on this slide and the next one. You can see that we specify that there should be 3 identifiers, at least one of which must be unique, and that there should be a system to identify same or similar names. I would encourage you to refer back to our publications on HTA reportable incidents, which contain advice on various ways this can be done. Where bodies are brought to the mortuary by the police with fewer than 3 identifiers, for example, their name and a police log number, asking the police to include the deceased date of birth or date of death would provide an additional safeguard. Where there are fewer than 3 identifiers, it's good practice to contact the police or the relevant coroner's office to obtain more information to confirm the identification of the deceased in writing and to keep documentation with the deceased record. A second wristband with additional details may then be added to the body. I've included that particularly because we've had 1 or 2 questions about what mortuary staff should do when a body arrives from the police without the necessary 3 identifiers. Also in traceability, we've included standards on the movement of bodies and the long-term storage of bodies, which we've learned from incidents reported to us are areas of potential risk. Finally, in relation to disposal that prevent the unnecessary storage areas and ensure that the wishes of families are met in a timely manner. Key to this is good communication with the coroner's office, and the communication flowchart that we developed some time ago is included in the code as an annex, with some minor modifications to reflect the latest coroner's regulations. Moving on to the last group of standards relating to premises, facilities. The focus of these to the new additions is on security, the adequacy of storage for normal workloads, and the contingency arrangements in place when this is not sufficient. The standards require that the premises are secure and well maintained, and that they safeguard the dignity. There should be controlled access to the body storage area and PM room, and the use of CCTV to monitor access. It's up to each individual establishment to decide whether they would benefit from the installation of CCTV. A risk assessment will help determine the level of security needed. But remember that CCTV may also be beneficial if there's an incident in the mortuary, such as accidental damage to a body, as it allows recordings to be reviewed as part of an investigation. And certainly in some of the more serious reportable incidents we've received, that's been very helpful to the trust in establishing and understanding what happened. We've been particularly concerned in the last 2 years about the inadequacy of frozen storage, which puts pressure on staff and poses a significant risk to bodies if they need to be stored for long periods in refrigerated storage. We require that bodies should be moved into frozen storage when they need to, and we advise that 30 days is about the right time if there's no indication that they are soon to be released or further examined, or before that, depending on the condition of the body. Where there is insufficient freezer storage to meet needs, there should be arrangements with other establishments or other contingency steps to ensure that bodies can be stored appropriately. And we also expect the matter to be escalated within the trust or the authority, so that it's identified as an organisational risk of which the board has sight and consideration given to mitigating actions that could be taken. With regards to contingency arrangements, we would like these to be assessed, particularly where they involve the transfer of bodies to other premises, to ensure that they're suitable and that traceability systems at those other premises are of the required standard. That is the main changes to the licensing standards. It really is important that you go back and look at the code and the associated guidance document on our website, which will give you more detail. But certainly in terms of thinking about the things that you need to do in the months ahead and in preparation for your next inspection, they are the key changes that you should be aware of. I've included in this slide the categorization of shortfalls. This is the basis on which we determine that a shortfall against a standard is minor, major or critical. So I think this is normally included in the back of our inspection reports, but it's a good reminder of how we make judgments and decisions about shortfalls. Overall, compliance in our post-mortem sector is actually very good. We rarely come across a critical shortfall, and very few major shortfalls are being found on inspection, and that's been the case for the last 2 or 3 years. Where we do have concerns, they have tended to be around the premises, and particularly in relation to a contingency storage at times of very high activity. Anyway, these categorization of shortfalls should help you understand how we make judgments about shortfalls against our standards. We hope that our new code and the guidance that we provided alongside it and alongside the standards will help you to continue to meet our standards, and we very much look forward to supporting you in the months and years ahead.